Hello, I'm attorney Paul Whalen from Afford Law. At Afford Law, we practice criminal and family law throughout Massachusetts. Our fees are all based on a sliding scale based on your income. So the less you make, the less you pay. Today, I'm going to be discussing with you whether or not you should take your criminal case to trial. Taking your criminal case to trial, easy for me to say, is a very important decision, obviously. There are many factors that go into making that decision. Among them are, what are the strengths of the Commonwealth's case against you? In other words, what's the evidence that they will provide and produce to try to convince the fact finder of your guilt? So obviously, the stronger their case, the less likely it is that you want to take your case to trial. If they have a lot of eyewitnesses, if there are a lot of forensic type evidence, video surveillance showing you committing the crime, things along that line, or if you make some sort of admission that you did the crime, that's obviously going to work very much against you, which would tend to make you not want to take your case to trial. You may have some good defenses. So perhaps you have an alibi defense. An alibi defense is essentially that you could not have committed the crime that you're charged with because we have evidence to show that you were nowhere near the scene of the crime. You were with somebody else and they can come in and testify, yeah, he was with me in another state at the time, so he couldn't possibly have committed it. That's very strong evidence on your behalf. Perhaps there are only a few witnesses against you, or maybe even only one witness against you, who is not very credible. They may have issues of their own. Perhaps they have a long criminal record, or perhaps they have some sort of mental health issue that would make them less than a reliable witness. Perhaps they were intoxicated at the time of the incident, therefore their memory and their recall of what took place can be questioned. Things along those lines your attorney can use to reduce their credibility to make your case more believable. The other thing you want to think about is, if you do go to trial, do you want to have a jury trial or do you want to have a bench trial? A bench trial is where a judge sits without a jury and the judge is the fact finder. So he or she makes the decision, guilty or not guilty. In the district court, you have an absolute right to a jury trial regardless of where that case is. But in the district court, you have a right to a jury of 6 persons who would decide your fate. So if you go to trial and it's a jury trial, 7 people will be chosen from the community. Your lawyer and the prosecutor will help pick those jurors. 7 people will be picked, and only 6 of them will ultimately make that decision. They have an extra person so that in case during the course of the trial, one of the 6 has to drop out for personal reasons or illness or something along those lines, they have an extra person. They can still deliberate with 6 people. So at the end of the trial, one person is chosen as the alternate. They don't get to decide the case. They had to listen to all the evidence, but they ultimately don't get a vote in your guilt or not guilt verdict. So if it goes to a jury, the jury has to be unanimous in their verdict. That means that they have to come back all guilty or all not guilty in order for there to be a final conclusion to your case. If even one juror says not guilty and the other 5 say guilty, it's at least what they call a hung jury. It would be a mistrial, and it would start from scratch. So if the Commonwealth wants to retry you, that means, go through the whole process again, start a new trial with a new jury and everything else. They can do so, but you've at least got a hung jury, so you're not convicted, at least as of that time. Sometimes what happens is, if you get a hung jury, the Commonwealth has had a chance to really look at their evidence, look at the witnesses that they have and so forth, and sometimes decide that it's not worth it to try to go at it again because they don't think they'll get any better outcome than they did already. But they have that right if it's a hung jury. So it's not a double jeopardy type situation where if you get tried and there's a hung jury, you can't be tried again. You can. That's their right. It's my opinion that you should almost always go with a jury trial because the odds are in your favor. So you only have to get 1 out of 6 persons to say not guilty. With a judge, it's only one person. So it's all not guilty or all guilty. It's all riding in that one person. And so it's 1 out of 1 chance as opposed to 1 out of 6 chances that we can get you a not guilty on someone. Everything else about the trial is the same, all the procedures and everything, except the selection of the jury and so forth. So you want to take a look at what the one of the other things you want to take a look at is what is the offer that the Commonwealth is making for you to plea out to the case. Are they offering something that is beneficial to you? Something such as a quaff. We've talked about that before, a continuation without a finding of guilt. If they're offering a quaff, you may very well want to consider that because there are two big advantages to a quaff. A quaff is not a conviction. So if you have a quaff on your record and somebody asks you, such as a landlord or an employer, have you been convicted of any crimes? If that's what's on your record, you can truthfully tell them that you have not been convicted. That's one of the big advantages. The other one is you'll be on a quaff for a period of time. So you'll be on probation for a period of time, let's say a year. So what happens is if you don't get rearrested during that 1 year and you satisfy any other conditions of your probation, the case gets dismissed at the end of that period of time. So ultimately, it's a delayed dismissal. If you take your case to trial, you can get a not guilty, and then you don't have probation, you don't have anything, you're free to go, the case is over. However, if you get a guilty, then you have been convicted. So there's a conviction on your record, and that's something that you'd have to deal with. And if the charge against you is a felony, you are now a convicted felon, and that will carry through for the rest of your life. So you want to be very careful about protecting your criminal record and keeping everything as clean as possible. So those are just some thoughts that I had about whether to take your case to trial or not. You should obviously speak at length with your attorney to decide whether it's in your favor to go forward at a trial or to try to plea out to the case. At Afford Law, we do practice criminal law and family law throughout Massachusetts. And our fees are based on a sliding scale based on your income. So the less you make, the less you pay. We are giving voice in the courtroom to the hardworking men and women of Massachusetts. Please feel free to visit us at affordlaw.org. We have a lot of information there for you. Feel free to book a free virtual appointment with me. I'd be happy to answer any questions you have about criminal or family law questions in Massachusetts. At Afford Law, we're making justice affordable.